Hello, everyone, and welcome to our webinar, Going Through Withdrawal, Avoiding, Minimizing, and Fighting Withdrawal Liability, brought to you as part of the Conn Maciel Carey Labor and Employment webinar series. This is the 6th regularly scheduled webinar as part of that series. Thank you for being here. My name is Mark Trapp. I am a partner with Conn Maciel Carey. I'm in the Chicago office, and I deal with all aspects of labor and employment, but particularly dealing with pension funds and multi-employer pension plan withdrawal liability. I also handle collective bargaining and dealing with federal litigation involving Title VII, ADA, ADEA, FMLA, all aspects of labor and employment. But I particularly enjoy maybe the wrong word, but I handle quite a bit of pension withdrawal liability, and I'll be speaking about that today. Since you are on the call, you probably know a little bit about pension withdrawal liability, and for that I sympathize with you, because those who know a little bit about it only know a little bit about it because they're forced to know a little bit about it by their circumstances, and those circumstances are generally not favorable for employers. So today we will be talking about different things that you can do as an employer to avoid withdrawal liability, to minimize withdrawal liability, and if necessary, to fight an assessment of withdrawal liability. I am first going to discuss some business planning, some issues that come up while you're running your business that you can anticipate, plan for, and plan ahead to deal with withdrawal liability, hopefully to avoid it. Let's see, the MPPAA, the Multi-Employer Pension Plan Amendments Act, was created in 1980. This is how withdrawal liability came about. It was an add-on to ERISA, which was passed in 1974, and ERISA was the statute that sort of was put in place to basically to try to protect pension plans. We'll be talking specifically today about withdrawal liability that's tied to multi-employer pension plans, and these are to be distinguished from single-employer pension plans. Run by a single employer or entity. We won't be discussing those because they do not concern us. Withdrawal liability under the Multi-Employer Pension Plan Amendments Act deals with multi-employer pension liability, and that generally comes from different funds created for different industries or unions, such as Central States, Southeast, and Southwest Areas Pension Fund for Teamsters. There are many pension funds throughout the country set up for different industries or unions, like Teamsters, operating engineers, bakers, United Food and Commercial Workers. There's lots of different multi-employer pension plans, and those are, as the name implies, plans that are set up for multiple employers to contribute to. Most of them are underfunded these days, and that leads to this withdrawal liability. Essentially, withdrawal liability, the shorthand for it that most people use is that it's an exit fee that covers unfunded vested benefits, but that's not exactly accurate, as you'll see hopefully by the end of the presentation. I discussed the differences between unfunded vested benefits and withdrawal liability, but that's the general idea, and that's the starting point for withdrawal liability. It's usually proportionate to you as an employer, your historic participation in the pension plan. Withdrawal liability can be carried along for years and even decades, and you may not know much about it or hear much about it until it's actually triggered. It's triggered by a reduction or a cessation of your legal obligation to contribute. For example, through a sale of your business, through closing it down, perhaps through layoffs, the union may be decertified or disclaim interest. You might be expelled from the pension plan. or you might bargain out in your collective bargaining negotiations and cease your obligation that way. I should point out right up front that the, sorry, skip the wrong slide here. The failure to make contributions that are still due under a collective bargaining agreement does not by itself trigger a withdrawal. It turns on the legal obligation, not the mere fact of a cessation. Let's talk a little bit about the different types of withdrawal liability. A complete withdrawal, as implied by its name, comes about when an employer permanently ceases to have an obligation to contribute to the plan, or ceases all of its covered operations, the operations that are covered by the CBA. So as its name implies, it's a complete withdrawal. As I mentioned already, the permanent cessation results when you close down, when you sell, when you bargain out, decertify, etc. The expulsion aspect that I mentioned can come about when a pension plan may not like the arrangement that was set up between a union and the employer, and they could choose to expel an employer. I've seen that happen several times. There are various subsets of issues involved with that, and I won't get too much into it. I did put in parentheses there on the slide, adverse selection. That is the phrase that some funds use when they choose to reject the arrangement that's set up agreed to by the union and the employer. They say that it's adverse selection in as much as mostly it deals with arrangements where the parties have agreed to contribute only for a certain subset of employees. And from the pension fund standpoint, they say that is those employees are the ones most likely to get benefits. For example, if you only contributed, if you grandfathered in, all the employees that were there, but cut off new hires, for example, from the obligation to contribute, the pension fund may look at that arrangement very seriously and say, well, no, we're not going to take that. And if you mandate it, then they might expel you from the fund, because only the older participants most likely to get a pension you would have an obligation to contribute for them, but not for the new hires, and they do not like that. So that's another way that a complete withdrawal might occur. A partial withdrawal, by contrast, is less than a complete withdrawal, and there are several ways for this to occur. First is when there's a 70% contribution decline over each year of a 3-year period. Each of those 3 years must be a 70% decline from the 5-year testing period before those 3 years. Sounds kind of complicated, but it's really not too terribly complicated. But just for our purposes, you basically need to know if you have a drastic decline in your business that requires less contributions to the pension fund over a 3-year period, you might want to check that and make sure that you're not bumping up against a partial withdrawal, because this can really be a bad deal all the way around, because you're paying withdrawal liability, but you're still obligated to the fund and you haven't exited the fund, and it's really just the worst outcome that there is because of that fact. My personal thoughts on it are that if you're going to pay withdrawal liability, you better have withdrawn from the fund completely. But in a partial withdrawal, that's not the case. It can also occur other than just this decline, excuse me, in contribution over 3 years. It can occur when you cease to have an obligation under one CBA, one collective bargaining agreement, but not all your collective bargaining agreements. So if you have more than one collective bargaining agreement that obligates you to contribute to a fund, to the same fund, but you cease your obligation under that CBA, but not under the others, that's known as a CBA takeout and can trigger a partial withdrawal. You can also have what's known as a facility takeout, which is the third example here of a partial withdrawal, where you cease to have an obligation to contribute at one of the facilities covered by a CBA, but not all of the facilities. For example, you have several facilities covered under one CBA, you shut down one of those but keep the others running, that can trigger a partial withdrawal. And you need to be aware of that for business planning purposes. You also need to be aware of this idea of control group liability. Under ERISA, all trades or businesses are treated as a single employer if they're under common control. And we'll talk a little bit about what that means. But you need to know that there's joint and several liability for all those companies that fit under that rubric of common control. And importantly, the pension fund, in the case of a withdrawal, can seek payment from any member of the control group, that is the entities that are under common control. I mentioned these attribution rules, and this is roughly similar to the tax code, where ownership can be imputed or attributed to various members of a family in different, depending on the relationship. That's something you need to be aware of. And know that courts have held that these trades or businesses don't need to be economically related to satisfy the common control test. So it can be vastly different businesses, so long as they're under common control. They can be in the same control group and be on the same hook for any withdrawal liability that may be triggered. The control group, as I said, is two or more organizations that are, in the ERISA phrase, quote, trades or businesses, and we'll touch on that here in just a second, and under common control. I mentioned that we would discuss common control. Here's just sort of a brief rundown of it. It can be parent and subsidiary relationship or brother-sister relationship under the tax code, and I cite that provision of the tax code there. I mentioned there was some overlap in this provision. Essentially, it comes down to interlinking entities, legal entities, corporations, partnerships, sole proprietorships, etc., that have an 80% overlap of ownership and 50% or more control. The main thing you need to know out of this control group is that you need to look into it because it expands the liability beyond the contributing employer. And if you're operating your business and under the assumption that, well, this business is the only one with an obligation to contribute to the pension fund, and if it goes under and there's not, whatever money's left goes to the pension fund, and then after that there's nothing left, you may need to make sure that you don't have control group issues, because the liability, as I mentioned, is joint and several, and it could be a nasty surprise if you're envisioning shutting down one business and that the fund's only recourse is against that business. That is not correct. The fund can recover from any member of the control group, and so you need to know what that is. So the second requirement that I mentioned was that it needs to be a trade or business. This is an organization engaged in an activity, and I see the list of two requirements there, for the primary purpose of income or profit and with continuity and regularity. We have a little bit, fleshes it out a little bit here on this slide, what that really means. It usually does not mean income that's received as an employee or through a passive investment or just a hobby, but it does extend. And this is the important one, and it trips up a lot of places, or at least they realize that this could be a trade or business, and it could be deemed to be a business that's part of the control group, because it extends to leasing activity or earnings as an independent contractor. Now, on this leasing part, I list here on the slide, for example, the owner of a withdrawn company might expose his personal assets if he or she leases property or equipment to the withdrawn company or third parties, even if it's unrelated to the withdrawn company, or earns income as a consultant to third parties. Now, what often happens is the owner of, say, a trucking company owns the trucking company and maybe also owns some trucks or equipment that are leased to the trucking company. Or owns, in this example that I list here on this slide, the withdrawn employer was a tugboat company, and there were some tugboats that were owned personally that were leased to the company. That leasing arrangement can be considered a trade or business and then lumped in with the rest of the control group when liability becomes an issue. This is what's known as the leasing property rule, at least here in the Seventh Circuit. And again, I'm in Chicago, and the Seventh Circuit is situated here in Chicago and covers Illinois and Indiana and Wisconsin. There are various circuits around the country, but here in the Seventh Circuit, which handles a lot of the withdrawal liability matters, they call this the leasing property rule, and the opinions have said that this is a categorical rule that leasing property to a withdrawn employer makes an entity a trade or a business, and therefore can be part of the control group and subject to the joint and several liability. I did pull up here and put at the bottom of this slide a recent case here from the Northern District of Illinois. Again, this is in the Seventh Circuit. The Northern District of Illinois is situated right here in Chicago as well. And at the end of March, this opinion came out, and it shows sort of the extent of this leasing property rule, where the court refused to apply an exception to the leasing property rule, even where the lease was rent-free and the business had not made any payments at all for insurance or maintenance or utilities, hadn't claimed any kind of the person hadn't claimed any tax benefits or anything, had just allowed this business to use the property, and that was enough to find another trade or business and expose the entity for additional liability. So that's a pretty broad rule, and that's something you need to be aware of when you're looking at business planning issues. I sum it up here. This is a quote from another case from a few years ago here in the Northern District of Illinois. In sum, this is what the court said, in sum, if an individual engages in a trade or business under common control with the withdrawing employer, by leasing his property to the withdrawing employer, he is personally liable for payment of withdrawal liability. I think that's a pretty accurate summation of it, and something that might cause you to think through the relationships that you have and possible control group issues. Summing it up here at the bottom, where an individual, one, owns the property on which a withdrawing employer conducts its operation. This is also true for equipment or other things, like I said, but this just deals with property. Two, leases the property to the withdrawing employer. And three, owns the withdrawing employer, or at least as part of that same control group. Then that individual is personally liable for the payment of withdrawal liability incurred by the withdrawing employer. Again, joint and several. That's something to definitely be aware of. Other issues, business planning issues that you need to know about. Usually when there's a merger, a stock sale, a reorganization, if you change your structure or spin something off, there's generally going to be no withdrawal triggered, so long as the obligation to contribute continues. And in most of those situations it does, but that's just something that you definitely want to double check. In a sale of assets, however, this usually as a matter of law, will end the contribution obligation, and under the statute, it triggers a withdrawal if you sell your assets. And asset sales have been pretty popular means of transferring a business for many years. That would generally trigger withdrawal liability and could be another unpleasant surprise. There is a limitation on the allocable, and I put there UVBs. Those are unfunded vested benefits. That's the starting point for a calculation of withdrawal liability. That limitation looks back only 5 years. So the purchaser accepts only the last 5 years of unfunded vested benefits. And that may make a difference, and I'll touch on that in a little bit. It may make a difference for the purchaser. But there is a section of the Multi-Employer Pension Plan Amendments Act, this section 4204, that you can use to avoid triggering liability at all, even in the sale of assets, if you're looking at selling your company. Now, a lot of these days, because the tremendously underfunded nature of a lot of these pension plans, asset sales are looked at with, they're really combed through to make sure as to what's what, and due diligence really matters in these situations. So if you're purchasing assets, definitely do your due diligence and figure out what withdrawal liability might come through that because we will talk about an issue called successor liability here in a minute, or determine whether you need to use Section 4204. If you're selling your business, you might want to avoid triggering withdrawal liability for yourself, and you can use Section 4204 to do that. The common law rule, the successor liability issue is, this successor liability, the common law rule was always that an asset purchaser, and this is why it became so popular, an asset purchaser was not liable for the seller's withdrawal liability or any other liability. That's changed some in recent years, and particularly as it concerns us, it's changed with regard to withdrawal liability. And courts have held that a purchaser of the asset, if deemed a successor, can be liable for the unpaid withdrawal liability of the seller. And it's pretty simple test too. I lay it out here on this slide. They pointed to these factors. If you had notice of the liability prior to the sale, and there's sufficient evidence of the continuity of operations after the sale. I list some of the factors there, and on the next slide, I'll talk a little bit more about them. There's a couple cases that I list here that you should be aware of that in recent years have discussed this doctrine of successor liability in the withdrawal liability context. And in this one, in the Ninth Circuit, this resilient floor covering fund, this was in California, and they found that the continuity of the customer base was the most important factor in finding the asset purchaser liable for the seller's withdrawal liability, just keeping the customer base, which seems pretty heavy-handed to me, but there you go. This Zaref versus Man Web Services was one in here in the Seventh Circuit a few years ago. They construed the notice. Remember, you need to have notice of liability prior to the sale. Notice was construed very, very broadly. And pointing to another case here at the bottom, this Heavenly Hannah Hotels from the Ninth Circuit a few years later, held that even constructive notice was sufficient, putting the onus on buyers to investigate the funded status of the plan. And in that opinion, the court held, well, a reasonable person would have checked and would have found out about it, so you're deemed to have had notice of it, and that can make you liable as a successor, which is, again, a pretty harsh doctrine if you're a asset purchaser thinking that you're not buying liabilities as well. Factors considered by the court in determining whether the enterprise is indeed a successor. I've laid these out on this slide under the bullets. If you use the same physical assets, equipment, building, real estate, same property, you take over the customer base, as I mentioned in that resilient floor covering case, that was the critical factor for the court there. Take over the account or fill existing orders, continuity of management, hire the employees or some portion of the workforce, take on other assets like their goodwill or trademarks, the name, same phone numbers, things like that. You hold yourself out as operating the same business, then the courts can't hold you liable as a successor. And then one comment on the notice, did the new enterprise have notice of withdrawal liability? This gets into where, like in the Heavenly Hannah opinion, where the court held constructive notice was okay. Basically, a purchaser using reasonable care or diligence would have discovered the liability. So courts have expanded this or played it out to its fullest extent that you can't hide your head in the sand and say, well, I never learned about any of this, and use that to avoid withdrawal liability. So in an asset purchase, you definitely want to be careful on both sides of the table. But definitely, if you're taking, if you're a purchaser of assets, you want to make sure that you've ferreted this out and determined if you can be a successor and what's going to happen with this withdrawal liability. That's what often happens in these types of situations. They sometimes don't go forward because the withdrawal liability is such an impediment to a deal. That can happen. I mentioned the Section 4204, and from a seller standpoint, a seller can avoid triggering a withdrawal if they meet these certain conditions, these three conditions that I've listed here as part of the sale of assets. First, it needs to be a bona fide arm's length transaction with an unrelated party. You can't sell it to your wife and avoid triggering withdrawal, or a wife to her husband, things like that. Has to be a bona fide transaction. Also, the purchaser must take on the obligation to contribute. So here, the purchaser, if you're going to avoid triggering that withdrawal liability for the seller, the purchaser has to agree to take on the obligation to contribute for substantially the same number of contribution-based units that the seller had, and post a bond that must remain there for 5 years. And the seller has to agree as part of the sale contract, and they're sticklers on this, they make sure that it's in the actual contract. Seller has to agree to secondary liability within the first 5 years after the sale if the purchaser defaults on withdrawal liability. A couple things to mention here. Again, this is all business planning issues and determining what you might do in a sale, or particularly an asset sale. Under Section 4204, the buyer assumes the 5 years of contributions history. Now, generally in withdrawal liability, if the fund were assessing it against the original owner, the seller here, then they would look back 10 years. And it could be the case in certain circumstances that 10 years ago, the company was doing better than it was 5 years ago. And so they contributed more. They had a more robust contributions history than they do within the last 5 years. So it may be that when the buyer assumes those 5 years, he's actually getting slightly better deal, or maybe potentially far better deal than the seller would have if withdrawal liability were triggered. So that's something to keep in mind if you have a seller that's been on a decline from 10 years back to 5 years, looking back 5 years. The buyer, as I mentioned, should analyze successorship unless if they're purchasing without explicit assumption. They should definitely analyze the successorship scenario, conduct thorough due diligence, figure out how you're going to factor in the withdrawal liability. You need to know about it by conducting thorough due diligence. You could negotiate a price reduction or escrow the money to cover withdrawal liability. You want to do something to make sure that you're not surprised. And like I mentioned, sometimes the transaction might not be worthwhile. Withdrawal liability could be something that might not be able to be overcome. There may be other issues as well, but this should certainly be one that's looked at and factored into in advance. Key points to avoid liability. Again, this is summing up some of the business planning issues. Conduct your due diligence, watch for successorship, account for that liability in any deal, and conduct careful estate and business planning. Again, looking at the control groups and things like that. Your collective bargaining agreement, you should be very aware of, and as that begins your obligation to the pension fund, make sure that your contributions are in accordance with the collective bargaining agreement. Oftentimes, I've dealt with folks who, they haven't policed it very well, and maybe they're making contributions that they're really not obligated to make under the CBA. For example, maybe you're not obligated to pay contributions on overtime, but you are. Maybe you're not obligated to pay contributions for vacation or for sick leave, or maybe there are hours caps in the CBA that for whatever reason have been neglected, and maybe you're contributing more than you should, and that's something that you should take a look at on a regular basis. Also, this is something, and I'll mention this later on, this reference to the MPRA, that's the Multi-Employer Pension Reform Act, and I'll talk a little bit more about that later on, and you'll see why I bring it up. But I say don't blindly accept rate increases, ensure proper language under MPRA. Well, what I mean by that is rate increases in recent years. This Multi-Employer Pension Reform Act of 2014 was just passed in, as its name says, the end of 2014. And it holds that the rate increases that are mandated by a rehabilitation plan from a pension fund can't be used against an employer for the purposes of withdrawal liability. And in your negotiations, it might not hurt to put language in your CBA as to the fact that these increases that you may agree to, because they are going to want the increases, especially if they have a rehabilitation plan. They'll say that's the way that it is. And it wouldn't hurt to get that understanding in writing, at least between you and the union, that These increases were mandated by the fund's rehabilitation plan and are intended, and the only reason we agreed to them is because of the fact that they're mandated. That will avoid any argument about it later on, and I'll discuss that a little bit more later when we get to the MPRA. And also, again, I mentioned the control group, just emphasize that on the way out of these business planning issues. Take a look at your control group, pay attention to any leased property or equipment, and make sure that you know who may or may not be on the hook for any withdrawal liability that's triggered as a result of any of these scenarios. Now, we've talked about hopefully avoiding withdrawal liability. Now let's talk about minimizing it and what are some steps that you can do here. I'll talk a little bit about the mechanics. So the calculation of withdrawal liability, as I mentioned, I think I mentioned this on an earlier slide, to determine the employer's withdrawal liability, the fund starts with this idea of unfunded vested benefits. And the way that, that you can think of that is, you know, a pension gives you benefits. Those are vested in an individual, so they're vested benefits. The difference between the amount of vested benefits that have been promised to the participants and the amount of assets, the amount of money that the fund has to pay those future vested benefits, is the unfunded portion. So those are known as unfunded vested benefits. There's a lot of these funds have huge amounts, large percentages of unfunded vested benefits. Some funds are funded only to the tune of 20 or 30% and declining. Most funds are well below the 100% funding level that you would want at a minimum. But that discrepancy there is the starting point for calculating withdrawal liability. So they allocate some portion of those unfunded vested benefits of the plan overall to an individual withdrawn employer. That there are various formulas under the statute that lay out how you calculate that, but generally they're assigned or allocated in proportion to the historic level of the employer's contributions relative to the contributions of all participating employers. One key to remember here, though, about withdrawal liability is that unfunded vested benefits and withdrawal liability are not the same. So that's the starting point for calculating your withdrawal liability, is your portion of the unfunded vested benefits. But that any amount of withdrawal liability is payable in level annual installments. There's a de minimis reduction here that I'll mention, and this just shows how pathetic the funding level is for a lot of these pension funds. If your withdrawal liability is less than $50,000, it's considered de minimis, not even worth bothering with, and they just write it off. If your withdrawal liability is between $50,000 to $150,000, then it's reduced on a sliding scale because of a provision of the statute. So that shows you the kind of numbers we're talking about. And most often withdrawal liability is discussed in millions rather than thousands. The 20-year cap is something that's very important. And I mentioned these annual payments that are determined under the statute as to how you actually pay withdrawal liability. There's a 20-year cap on that amount of payments. And if you have not satisfied the full amount of unfunded vested benefits, that's okay, because under the statute, you're liable only for withdrawal liability. And withdrawal liability, as I said, is not unfunded vested benefits. Withdrawal liability is the amount that you're liable for, which includes this 20-year cap, the 20 annual payments. There's these a couple other caps that I should mention here. I mentioned the de minimis and the 20-year cap. The sale of assets limitation is another provision in the statute that can reduce withdrawal liability. This is to be distinguished from that Section 4204. Section 4204 does deal with sale of assets and can avoid triggering a withdrawal. The sale of assets limitation is, along with the insolvency limitation, are both limitations that are found in Section 4205, which is mentioned at the top of this slide, of ERISA, which can result in substantial savings depending on the worth, the value of the company at the end of everything. For example, if you're declaring bankruptcy and going insolvent, or if you're sold off all or substantially all of your assets, there's other limitations that can kick in and reduce the amount of unfunded vested benefits that can be allocated to you as a withdrawn employer. I mentioned those here on this slide, and I won't dwell too much on those, but I do discuss those, and both of those are found in section 4205. So just know that if you are if you sell all or substantially all of your assets at the end, then that can limit the amount of UVBs that are allocated to you. And same with insolvency. If you're insolvent or undergoing liquidation, as the statute says, then you can reduce or limit the amount of unfunded vested benefits that can be allocated to you, which can make a big difference in the calculation of withdrawal liability. So be aware of those. Also, the timing matters quite a bit. Under ERISA, the date of a complete withdrawal, and I quote from the statute there, is the date of the cessation of the obligation to contribute. Again, the cessation of the legal obligation that we're talking about, not just the mere fact of contributions. And the date of withdrawal can make a huge difference. I had a case one time, and for this you need to know the calendar, the plan year for your multi-employer pension fund. The plan will have its own plan year, and most often this is coincides with a calendar year, so it runs from January 1 through December 31. But often plans may have their own plan year that may run, for example, from May 1st of one year to April 30th the next year, or July 1st of one year to June 30th of the next year. And those are plan years, and you need to know those to determine the timing. Again, because the date of the cessation of the obligation to contribute is the date of a withdrawal, and withdrawal liability can change substantially year over year, and it's calculated that way year over year. So you need to know, like, for example, if you're planning on shutting down your business, it may make a huge difference if you shut it down now versus waiting a little bit to get into the next plan year. Or you may want to shut it down now rather than get into the next plan year. The timing just makes a big difference, or could make a big difference. And, like I said, we had a case a while back that dealt with this interplay, and it was a big difference of, I think it was more than $2 or $3 million difference. And it turned on the date of December 31st versus January 1st. And the fund had kicked us out and said that it was effective on January 1st. So our last day of contributions would be December 31st. Well, we pointed out that, hey, that means that we're in the next plan year, because that particular fund had a plan year that coincided with the calendar year. And that made a huge difference, and one that was favorable to us to the tune of, a large amount of money. And that was a silver lining in an otherwise bad situation with withdrawal liability. And when we saved a big chunk of it by successfully pressing the point that we were in the next plan year, because our cessation didn't occur until January 1st rather than December 31st. So it can make a big deal. You need to check the fund rules, figure out when your CBA expires and all this kind of stuff to make those determinations, but that's something to consider in trying to minimize any withdrawal liability. Now, I talked a little bit about how withdrawal liability is actually paid and how it's not unfunded vested benefits. They don't just say, here's your portion of unfunded vested benefits, pay this off. They can only make you pay an annual payment, and they can only make you pay that for 20 years. So here's figuring out your annual payment can be a very big deal, as it can reducing the unfunded vested benefits down to withdrawal liability. It can make a big difference. And as I said, withdrawal liability is not unfunded vested benefits, because withdrawal liability implies the application of the annual payment and the 20-year cap. So calculating your payment is something that you should do, and it's very simple. It's second or third grade math, if that. You take your contribution base units. Now, your contribution base units are the unit under which you contribute. So, for example, most often under a collective bargaining agreement, you contribute so much per hour. If that is the case, your contribution base unit would be the hour. So the determination would be how many hours did you have an obligation to contribute for this year. And you want to look back 10 years and check that history. You don't include the current year. So if my plan year ran from January 1 to December 31, I would look back for not the 2020 contributions, but from 2019, looking back 10 years. Each year, how many hours did I have an obligation to contribute for? Or if your base unit is a week or a day, something like that, you might have other units under which you contribute. Maybe you just make a weekly contribution and that's how it's determined under the contract. But whatever it is, that's your contribution base unit. You look back 10 years and figure out that history, and then you'll take the highest, if you look below that where I say annual payment is 1 times 2 on this slide, the highest CBUs, the highest contribution base units for 3 consecutive years. So you look back those 10 years and take the 3 highest consecutive years that you had an obligation to contribute, add those together, and then divide it by 3 for your highest CBU average. And then you multiply that by number 2, which is your highest contribution rate, which also looks back 10 years, but includes the current year. And that's almost always what you're paying right now. Your highest rate is, I've never seen it otherwise, which is what you're paying right now. However, I do mention to consider the MPRA, the Multi-Employer Pension Reform Act, because bear in mind that I said that if you are looking at the contribution increase and it was mandated because of a rehabilitation plan, then those increases after plan years beginning after December 31st of 2014 will not count against you for purposes of calculating withdrawal liability. And that will be very important in calculating your annual payment. So you figure out that highest rate, you figure out your highest average CBUs, and you multiply them, and that's your annual payment. Then the fund can only make you make that payment each year for 20 years. That can be significantly less. Your actual withdrawal liability can be significantly less, and in many cases today is much less than your unfunded vested benefits would otherwise be. Again, where I mentioned this MPRA silver lining is that when you're calculating this annual payment, your increases may have gone up. Your contribution rate increases may have gone up since December 31st of 2014, but they don't count against you when you're calculating withdrawal liability. So for purposes of determining your highest contribution rate, you may be able to go back and do that calculation using the highest rate that was in effect before December, your plan year, that was in effect on December 31st, 2014. So that's actually a pretty potentially very significant savings for employers, and you need to be fully aware of that. I say clouds on the horizon. Well, I don't know. There is a recent arbitration opinion that just came out a couple months ago that that comports with what I just described to you about withholding the not using the higher rates since 2014, and the arbitrator ruled against the fund that was making the argument that because their increases were so-called benefit-bearing increases, that somehow skirted the MPRA prohibition on their use. The arbitrator, I think, properly ruled against that, and that's the first decision that I'm aware of on that. But in the Pension Benefit Guarantee Corporation proposed a regulation to reflect these charges, these contribution rate increases, and to allow some of them to be used. I filed comments on behalf of Conn Maciel and Carey arguing against that, and I think it's very clear under the statute that that cannot be done, and so hopefully the PBGC will follow the statute and not do that. But you need to be aware of it because if this regulation were to ever, the proposed regulation were to be in effect, it would negate the benefit of the MPRA, the Multi-Employer Pension Reform Act, as the funds would be, and many of them would seek to use the post-2014 contribution rate increases against an employer in calculating withdrawal liability. I think to the direct and explicit command to the contrary in statute. So know your liability here. This will help you minimize it. An estimate, you can get an estimate from the fund through these information requests. You're entitled to an annual estimate under ERISA, and you ought to get one. You can also request other financial or valuation reports. You should be aware of the fund condition. They're bound to send out annual funding notices telling you whether they're in critical status or endangered status or critical and declining status, things like that. It also might behoove you to know of their investment returns and assumptions, and I'll tell you about a recent case that's out there now that deals with these factors. Might not hurt to know some of the arbitration decisions that your fund has been involved in, and you're entitled to ask for those as well. Under ERISA 101L, you are entitled to an estimate, as I said, and I've highlighted a couple of things that the fund has to give you, but I bolded this one, the application of any limitations you see on this slide. So when you request an estimate, then oftentimes funds will skirt this requirement of the application of any limitations, and then what they'll give you is your supposed number of withdrawal liability, but it's really your unfunded vested benefit. And so you get scared to death and think, holy cow, 15 million or whatever figure they've told you, there's no way we could ever withdraw. I might as well forget it. Well, that in many situations is not your actual withdrawal liability. That's the unfunded vested benefits. And that's why I think it's key that the funds are supposed to give you the estimate, including the application of any limitations. And the statute specifically talks about the withdrawal liability limitation of the 20-year payment cap. So you may follow up or you may not, at least be aware of it, but you are entitled, the only thing you're liable for under the statute is withdrawal liability. And withdrawal liability, as I mentioned already, implies that annual payment and the 20-year payment cap, and it may be much less than the number that the fund is giving you, because the fund is giving you the number that corresponds with your unfunded vested benefits. And those are very different things. Certainly today, that's true. You're entitled to this no more than once every 12 months, and I encourage you to get it. You're also entitled to other information under Section K, but I won't discuss those details here right now. So in minimizing, know that timing is everything. You have the 10-year drop-off. I talked about the 10-year drop-off. That's, remember, when you look back for your contribution base units, you're looking back 10 years. This is where I talk about the drop-off. If your company's best years, your highest contribution base units were 10 years ago, or 9 and 8, then timing may be everything. Maybe as you progress through these next couple of years at a lower level of contributions, your high years will drop off, and then your annual payment decreases. And even if the unfunded vested benefits are going up, your payment is going down. And it may be advantageous to be aware of how that works and how it could work in your favor, depending on how your company historically did versus how it's doing now. Be aware of the 20-year cap. As I said, that's important, and present value. They can argue about how to pay in a lump sum, and you have the right to pay in a lump sum under the statute, and negotiate rates. I think there's an argument that the rates are already fixed, and I'll touch on this again and with the recent opinion that I'm going to discuss here in a little bit. And need to know of your contribution rates and withdrawal liability, and the effect of the Multi-Employer Pension Reform Act. Again, see what the fund may try to argue is your highest rate, but bear in mind that under the MPRA, you may be entitled to exclude that highest rate and go back to your 2014 rates, which can drastically reduce your payments. Now let's talk here the last 10 minutes about fighting withdrawal liability. If you end up in that undesirable situation, just know that you may just get a letter that says, here's a withdrawal liability assessment and you owe it to us and you need to start paying it now. Well, arbitration reigns supreme, and I always think of it as a home game for the fund. the statute is slanted pretty severely in favor of the pension fund. And you have to use arbitration to raise a lot of issues when you're fighting it, and you don't want to miss any deadlines that trigger arbitration. So here I put this little handy timeline together for you. You get the assessment and you have to start making interim payments. You'll see here I say pay now, dispute later. I'll talk about that in a second. But that means you have to start making payments. And you'll say, well, I'm an American. I don't have to start paying anything until, you know, God and or my lawyer or the Supreme Court tells me otherwise. Well, that's not true in withdrawal liability. When you get that letter, they'll say you have to start making payments. And as a general matter, you do have to start making those payments, even while you contest it. You contest it first by filing the middle step there is that request for review. You have 90 days from your receipt of the assessment to file that request for review. And that request for review is what triggers the window for arbitration. So do not miss the deadline to file a request for review, or that could have severe consequences for you. The notice of initiation for arbitration, as I said, is keyed off of the date of your request for review, and the 60-day window to initiate arbitration opens after the earlier of the fund response to your request for review, or 120 days after your request for review if the fund has not responded. So don't send off your request for review and then the fund does, you think, well, I'll get to that when the fund writes back. Oftentimes the fund knows that these procedures are sort of arcane and they won't respond because they want to see if you know that you have to initiate arbitration anyway. And you might not get a response from the fund. And if your clock runs, then they'll say, too bad, so sad. As I said, you have to, it's pay now, dispute later mechanism. You have to make the interim payments even while you're disputing it. And watch out for default. Default on these payments would be a missed payment on the payment schedule that the fund gives you, but there's also insecurity defaults. And if you're interested in learning more about this, I've written an interesting article that discusses all these differences and the sometimes minor, but sometimes pretty major differences that flow from the different types of default. Mainly, though, what you need to know is that the default is a failure to make payments, and if you don't make the payments, the fund could bring a lawsuit to collect those delinquent payments. Most of them wait until you default, and then they'll accelerate the entire amount, which the statute gives them the right to do. This failure to make a payment can lead to a default if it's not cured within 60 days. So if you don't make a payment under the schedule, the fund will send you a letter saying you missed your payment, you have 60 days to pay it. You need to pay it within 60 days because if you don't, then the fund very well may accelerate the entire amount of the withdrawal liability rather than just that outstanding portion. And that could be a big and nasty, unpleasant surprise as well. Litigating assessments, you need to know about a little bit about the payment of filing fees and the use of the AAA. This is an arbitration association, and in 2013, they unilaterally increased their rates. What had previously been a flat $650 fee in almost every instance to initiate arbitration was turned into a schedule, and it resulted in filing fees of up to, you know, ridiculous amounts. That they were capped, I think, at something like $70,000. And this isn't the amount that goes to the arbitrator for his or her service. This is the amount just for the privilege of contesting their assessment. And it was just these ridiculous fees. Well, I thought about it, and some other people raised an issue, and it took them a long time. I was the only lawyer in America, actually, that filed comments after the AAA applied for pension benefit Guarantee Corporation approval of their new rule. And several of us filed comments, and then the AAA filed a response, and then I was the only lawyer that filed a response to the rest of it. Happily, the PBGC just maybe 5-6 months ago in December 2019 took those considerations into account and reduced the fees back down to a much more manageable level, ranging from $2,500 to $5,000, and reinstated the requirement that they be split with the fund. The new rules from 2013 under the AAA had called on the employer to pay the entire fee. And like I said, that could be $12, $13, $15, $20,000 just to initiate arbitration. And that's a big chunk of cash to come up with for an employer that has already withdrawn, probably because of financial circumstances. The PBGC also made clear that there's no more unilateral selection of the arbitrator by the AAA, so you're protected somewhat there too. I still think that the rules are maybe not entirely in line with what the statute says, but this is by far a much better deal than existed for those 5 or 6 years that the AAA was allowed to get away with this. This decision that I've mentioned a couple of times that deals with actuarial assumptions, and that may make a big deal in the calculation of withdrawal liability, because the interest rate assumption that the fund uses or its actuary uses to calculate the unfunded vested benefits has a very dramatic effect on the amount that's allocated to you as a withdrawn employer. And this case that just came out of New York, the Second Circuit at the beginning of this year in 2020, National Retirement Fund versus Metz Culinary Management, was a significant win for employers in that regard. So if you're looking at contesting a withdrawal liability assessment, and particularly actuarial assumptions that are used, because many funds started, in my view, manipulating the system to use a higher rate for their funding purposes than they did for the calculation of withdrawal liability. And I thought for many years that that was improper. And finally, we now have a appellate court decision. This is the first of its kind. And kudos to the guys who pushed this, because they won that issue. And it hopefully will have significant repercussions down the road for other parties litigating this and for other uses of interest rates. One case that I cited here at the bottom, the Sofco Erectors, just came out last month in the Southern District of Ohio, and it rejected this Segal blend, which is a blend by the Segal company, some actuaries, and that's what a lot of the funds have used instead of their minimum funding rates. They've used that, and it reduces, it increases a reduced interest rate increases the amount of the unfunded vested benefits and can drastically increase the withdrawal liability. And this court in the Southern District of Ohio, following the Metz Culinary opinion, rejected the use of this blend. And so that's a welcome development, and it may be welcome for you if you find yourself litigating an assessment. So pay attention to the actuarial assumptions as well. Also, another big issue that's come up recently is the credit that you get for a prior partial withdrawal. If you've had a partial withdrawal and are having another partial withdrawal or potentially a complete withdrawal, you're entitled to a credit. And here in the Ninth Circuit, at the end of 2018, they issued an opinion which I think is entirely wrong and completely misunderstands the fundamental difference between unfunded vested benefits and withdrawal liability. And we'll see how that plays out, but that's the only opinion of its kind. And again, I think it's completely an incorrect reading of the statute and almost nonsensical reading of the statute. But I think these judges did not understand that fundamental difference. And so they come out with, they say bad facts make bad law, and that's what we ended up with here. And it ended up being a decision that you may have to try to work your way around. But if you're in that situation, certainly want to take a look at it and discuss it with counsel. What about COVID-19 and withdrawal? Well, this coronavirus stuff may come into play for you and your business when you're considering all of the things that we've talked about. If you're looking because you have to close down or sell, you might trigger a withdrawal, and you definitely want to know what that may mean for you before you make that jump, take that plunge. Remember, there may be partial withdrawals. So if your business is declining, or you're laying people off, or you're shutting down a facility, or bargaining out of one contract, pay attention to that. It could trigger a withdrawal. And these are things that are very real and very now in this coronavirus situation. If you're reducing hours, that could result in a partial withdrawal. Also, just the stock market volatility and the drop, that's led to certainly, I guarantee that the stock market going down this year was not what these funds were anticipating. And so there will be more underfunding of the funds and more allocated unfunded vested benefits. The House a month or two ago passed this Emergency Pension Relief Act as part of the coronavirus relief bill. It stalled in the Senate. There was a couple of provisions there. I don't think it was very realistic, and neither did the Senate. But who knows, there may be some sort of bailout coming for pension funds as a result of this. Seems that from the pension fund standpoint, they may correctly be thinking, everybody else got one, why can't we have one? And who knows, there may be some changes coming, and if so, you'll want to pay attention to the Employer Defense Report or our blog there at connmaciel.com. And there's my contact information right there on the slide. So if you need to get in touch with me or ask me a question, I'll be happy to discuss any of these issues and or circumstances with you. I hope that you've enjoyed this presentation and that you've learned something and found it informative. And thank you for joining this Conn Maciel webinar as part of our 2020 Labor and Employment webinar series. Thank you very much.